In the matter of Gerald Fazio versus Altice USA, we'll have appearances of counsel, please.
Good afternoon. Dana Wheeler, law officer Dana Wheeler on behalf of the Gerald Fazio.
Good afternoon, Philip Jones, Connery LLC for the defendant. With me is Daniel Jones and Mayor Brown LLC, admitted prosecutor.
Welcome, counsel. We're always pleased to have amici in front of the court, and we're generous beyond the 5 minutes, but I would ask you to have in mind no more than 10 or so minutes as you prepare mentally for the opportunity to speak. Ms. Weaver. And 10 minutes does not apply to you, of course.
Good afternoon, Chief Justice and Honorable Justices of the New Jersey Supreme Court. If it pleases the court, may I reserve 5 minutes for rebuttal, please?
We'll have you back, perhaps for a little less. Go ahead.
Okay. So the question presented in this case is, can mutual assent to an arbitration clause be established through a business practice of sending a customer service agreement without proving that practice was followed as to the plaintiff? The answer to that question is, under these facts, no. There was no knowing waiver or mutual assent under the facts that exist here. There is simply no documentary evidence that Mr. Fazio ever received or saw the arbitration clause, even though under Altice's purported business policy, there should be documentary evidence that the arbitration clause was sent to him. The testimonial evidence of business practice is speculative and does not establish routine or habit. It simply states that it was Altice's policy that this would happen, but there's no details given as to who was responsible for sending the email or how it was tracked. Was it done in the store? Was it done through some corporate office? There's no evidence on the record concerning that at all. Altice's burden initially should be a prima facie case of mutual assent, which it did not meet here. Under New Jersey law, that mutual assent must be demonstrated clearly and unmistakably, and the assent, when it concerns a waiver of a right, must be knowing. Here, there was no and there is no discovery needed because Altice did not meet its prima facie burden. The process that Altice adopted precludes assent without that email. The process that Altice used in order to secure assent to its arbitration clause was to have people agree to it beforehand. So it's undisputed that Mr. Fazio and all other customers of Altice were required to provide their assent to an arbitration clause without seeing it. So mutual assent could not have taken place at that point in time. Perhaps a saving grace of Altice's process was that when it was supposed to email the clause, excuse me, to the customer later on, there was an opt-out provision within 30 days. So that may perhaps under a different case save that clause from being unconscionable because there could not have been any knowing waiver from the get-go. The problem here is that there was no opportunity to opt out. There is no evidence that the actual arbitration clause or the opportunity to opt out was ever sent to Mr. Fazio. If viewed as legally sufficient, the facts of this case, that a corporation can bind someone to an arbitration clause simply by saying that it has a policy of sending that arbitration clause to people after they have already assented to it, it would create a situation in New Jersey where a corporation could just say that they do that and never have to prove that they actually do. You could have lots and lots of people bound to all sorts of arbitration clauses without ever having seen them. And that result would be contrary to the established law of this court and the state of New Jersey. If the court has any questions, I'd be pleased to take them.
The affidavit in this case from Mr. Fazio says that he got some emails from Altice during the relevant time period. I take it that those emails related to the general subject matter of this appeal and not some other offer?
I'm sorry. Yes, Chief Justice. So the emails that he received were related to things that Altice's receipt did say that he would receive, things like I think it was an auto pay agreement maybe and a handset agreement, things that were sort of peripheral to him becoming a customer of Altice.
And it also says that he searched for but could not find the particular email in question here with the service agreement, but he doesn't say that he didn't get that email. Can you comment on that?
Yes, so I think that one of the incongruities of this case, and one of the reasons that it's distinguishable from some of the cases that Altice and the amicus have cited, is because when a physical copy of a document is handed to someone, the person is a participant in that transaction. And so if it wasn't actually handed to them, they can dispute that. However, in this case, Altice is saying that their established business practice was to email the arbitration clause to someone afterwards. And that's something that only Altice could have personal knowledge of. There's no way for Mr. Fazio to be able to dispute whether or not the email was sent because he wasn't a part of that process.
And there's no discoveries taking place, right?
There was no discovery.
So they've never been asked to produce all documents, which could obviously include a sent item, email indicating this was sent, or some other proof of email. Have they ever said they don't have that in the court proceedings that have taken place in this case? Or is there any record whatsoever as to whether or not they have a document that shows that this was sent to your client?
So there is nothing on the record. There's been nothing presented in court. I can say that there's been an informal request for it, but the email wasn't produced.
But it was their motion to compel arbitration.
Yes.
So it was their burden in theory to produce anything necessary to compel arbitration?
Yes. So we take the position that the party that is saying that there is a valid arbitration clause has the initial burden of showing that there was indeed a valid arbitration clause, and that in the state of New Jersey, that does require establishing a knowing waiver and voluntary assent to a waiver of rights.
You said there was an informal request. Are you at liberty to tell us what came of the request?
Well, it was before the motion to dismiss was filed. Conversations between counsel.
I'm assuming you don't have proof of a sent email.
No, there's no proof of you mean of an email from Altice to Mr. Fazio? No, we don't believe the email was sent. We couldn't find it. Mr.
Fazio look at his, do you know if he looked at his deleted items in his computer?
I don't know. He searched his email. So what we set forth in the certification was exactly what he searched for.
You can search your inbox, but some people never delete anything, but you can search your inbox. And if something is been deleted, that might not necessarily come up in that search. So, or I'm not asking for your privileged conversations with your client, but do you know whether anybody has looked at, he or anybody else has looked for this in his deleted items or other parts of, folders in his computer that may exist?
Justice, the search that he put forward in the certification is, as far as I know, the only search that was done. But I would say that the burden, we believe, is on Altice to show it's their process. They said that this email was sent, and the best evidence would certainly be that email.
But it's still the representation that I searched my emails. I have to say, I don't know what that meant.
Well, I think it was really just an effort to see whether there was an actual arbitration clause that was sent to him.
I had a similar question as Justice Patterson, and I know we're trying to get to the same answer. What does he mean by he searched his email? He went on his phone, put in a search term, and tried to see what came up. Did he go on a laptop? Because oftentimes you can search email in a different platform and everything might not come up that is available in the wide universe of the email folders. So do you have an understanding of exactly what that meant to search his email, that he searched his email, that he put in one search term on one occasion and didn't see it, or something else?
So, Justice, I do not know whether he searched it on a computer or his phone, but in the certification, we did put the 3 search terms that he did search for, which I think were Altice, Optimum, and service agreement. And nothing came up from Altice concerning that.
In his inbox?
In his inbox.
So we don't know. Do we know? We just don't know what.
Yeah, I don't know. But I sort of regret that that's become a focus both on the appellate level, because I don't think that Mr. Fazio had an obligation to do anything. But the effort here was to see if there was a valid arbitration clause, because if there was.
I understand, but there may be an email. Do we know whether there was you're obviously, and I don't want to put you in a spot, you're the lawyer representing a client, but if there is an email which is as described by Altice, what does that do to your argument? And my next question is, should we remand to find out if there is an email?
So I think that if there is an email, then the burden was on Altice to produce the email. I don't think at this point in time it would make sense to remand, for example, discovery or further proceedings, because there was no email presented in their prima facie case, and that would essentially be giving them a second bite at the apple. They submitted the testimonial evidence, and the testimonial evidence was also very weak. So I don't think that remand is necessary.
But do you understand what I'm saying? If there was an email, it's a game changer if that is true. If an email as described by Altice.
If there was an email, I think the case would have proceeded differently. I think that the email would have been presented as evidence at the motion to dismiss.
But do you understand the significance? If there is an email saying what they say it says, that either he received or they sent or whatever it might be, that could be rather significant for this ultimate question of whether this case belongs in arbitration.
Well, Justice, I think that that would make it more akin to Skews v. Pfizer, because there would be documentary evidence, the fact that there was an assent to the contract clause, whereas this case is different because there just is no such evidence. I do think it would be a different case had an email been presented from the beginning.
How would your client assent to binding arbitration if he received the email that they say they sent when your client first visited the store in November 2019?
So I'm going to quibble just a little bit with your question, because I don't think that Altice did say that they sent the email. They said that they would have sent the email under their practices.
My question is, let's pretend that they had a business practice to do this and that they introduced sufficient evidence to establish that they followed that practice. And let's further assume that they sent the email, your client received it. How does your client assent to binding arbitration once your client receives the customer service agreement?
So I don't want to speculate about where the law of this court would go if that happened, but I would venture to guess that perhaps because of the way that Altice set up its process, it would happen 30 days after the agreement was sent. And if he didn't opt out, because under the process that Altice used, they would have sent the arbitration agreement, and within that customer service agreement was a provision for 30 days to opt out without any consequence to the customer.
Right, now I'm not talking about opting out. I'm talking about accepting the terms of the customer service agreement. There's a paragraph in the customer service agreement that talks about how one accepts the terms of the agreement itself. And there are many ways a customer could go about accepting the terms. One is by agreeing in writing. Did your client do that?
To the arbitration clause, no.
To the terms of the service agreement, customer service agreement.
I would say yes. I believe he did.
He did what?
Well, he signed the receipt that purported to bind him to the customer service agreement. And under the process, the agreement would then have been sent to him.
But the receipt when you say he signed the receipt, are you talking about when he purchased the service plan on November 20th, 2019? Or are you referring to when he returned 5 days later or thereabouts to buy a phone?
So I think that both the retail installment agreement and the service agreement purport to incorporate the entire customer service agreement.
I'm trying to get an understanding of what happened on the first day he went into the store. When he went into that store, he bought a service plan and they gave him a receipt, which essentially said, we're going to email you the terms and conditions, purportedly the customer service agreement. My question to you is, if that occurred, if they actually emailed it and your client received it, how would your client assent to the terms and conditions of the service agreement as of November 20th, 2019, when they emailed it?
So Justice, I think it depends upon what part of the service agreement you're talking about.
The whole thing.
Well, I think that the arbitration clause or any other part of that contract that involved a waiver of rights could not have been assented to in advance. But I think that one could make the argument that, for example, the agreement to provide service and pay your bills on time may have been assented to immediately.
Well, that's what I'm trying to get to. How does your client show that he's agreed to the terms of the customer service agreement? He can do it in writing pursuant to paragraph 2, which is JA 24 in the record. He can do it by emailing. He can do it somehow online. He can do it in person. He can do it by paying for the service or the device. He can do it by opening a device package, or he can do it by activating or attempting to use the mobile service or the phone. Many, many ways. Are you saying that emailing this service agreement, customer service agreement, with those methods of acceptance is insufficient to prove mutual assent when it comes to binding arbitration?
I would say that those are insufficient to establish mutual assent when it comes to the waiver of any right, statutory or constitutional, because that's the law of the court. So I think that different parts of the relationship between Altice and Mr. Fazio could have been established at different points in time, but that when you're talking about a waiver of a right, there does need to be some sort of affirmative assent. And I think in this case, it probably would have happened if the email had been sent, if 30 days passed and he didn't avail himself of the opt-out provisions.
Say that last part again.
So I think that the mutual assent or knowing waiver as to the arbitration clause or any other waiver part of this contract probably would have happened if the email had been sent 30 days after that, after he didn't avail himself of the 30 days to opt out.
So I'm going to say it differently and tell me if I've misunderstood. You're saying that if there were proof that the service agreement had been sent and no opt-out, by the end of the 30th day, that's assent?
I think that under this court's precedent, that would probably be assent.
That would be automatic without him doing anything except not opting out.
I think that that's probably in accord with Skews v. Pfizer. Like having a condition, making something a condition of continued employment. If you continue acting in this way and you've been told that you're going to be bound to an arbitration clause if you continue to be employed, or if you don't opt out, as in this case, that is probably under this court's precedent when assent is established for a waiver of a right.
It's different from Skews though, because Skews had an acknowledgement.
Yes, Justice, I think this case is very different from Skews factually because there is no acknowledgement. There weren't nearly as many procedures put in place to assure that the customer understood what they were waiving.
And did you respond to Justice Fashali's one of his questions that with regard to your client agreeing to the customer service agreement, that there was agreement with your client to the terms of the customer service agreement, except for the waiver portions, that there was agreement with the customer service agreement at the moment your client signed the receipts because the receipts encompassed the customer service agreement?
So I think, I'm sorry.
I just want to make sure.
I think that that's a difficult question to answer because if another term of the contract were at stake, then there might be different arguments available concerning whether there was mutual assent. So hypothetically speaking, I would think that there is probably assent at the point of sale for most terms of the agreement. But because New Jersey and the United States Supreme Court have also recognized that the waiver of statutory and constitutional rights do require an intentional relinquishment of that right, that any waiver of rights in that contract, including the arbitration clause, just the assent is procured differently.
How could he assent if he hasn't even read the terms and conditions? How could signing the receipt on November 20th, 2019, when he bought the service plan that says you'll get an email of the terms and conditions in and of itself evidence that he assented if he hasn't read the terms and conditions yet?
Well, I agree, but I think that under the established cases that people can assent to a contract without seeing it. They can assent to the contract through a method of conducting themselves with others in a pattern of business.
I'm sorry, I didn't understand your answer to Justice Fishelli's question.
I think that the case law surrounding general contract law does establish that people can enter into a contract without signing or without seeing it or without reading it. So I think that's why the terms and conditions of the contract concerning, for example, them providing service and how much he'll pay for it could have been established separately from the question concerning a waiver of rights.
If you haven't seen or read the contract, how do you know what's being mutually assented?
I agree. I think it's very difficult to establish mutual assent if somebody hasn't seen or read the contract. But I don't have the case immediately in front of me.
Doesn't contract law differentiate between reading and having access to a contract? In this, obviously, it's not a defense to a contract to say, I don't know, I just signed whatever they put in front of me. I didn't read it. That's not a defense to a contract action. But this is not a question here. This goes a little bit further than that, doesn't it? The question is whether or not he waived rights before he had access to the waiver.
Yes, I'm sorry. I think I misunderstood before. So with regard to the waiver of rights, it's our position that Mr. Fazio and nobody else could possibly waive rights in advance of seeing the arbitration clause. The law of this court requires that arbitration clauses have this very specific language so that people are on notice and understand what they're waiving. And if he couldn't read it, he definitely could not have assented to such a waiver.
It's not so much as could or couldn't read it, because I think it's clear in the law that if you give a contract to somebody and they throw it in trash and don't read it, that's not an excuse. But that doesn't mean that there's no contract if there's an execution of a contract. But your argument seems to be that he could assent to it in advance of receiving a copy of it?
No, I'm sorry. I think I wasn't clear. So my argument was with regard to other terms of the contract, the general business relationship between them. With regard to the waiver of statutory and constitutional rights, I don't think that could have been agreed to in advance under the law of this court, because it has to be a knowing waiver.
Let's say this was the other way around in Altice, what decided we're giving this particular customer too good a deal, and a month in or 2 months in, they say we're gonna give you a new contract. This is too good a deal, and that's not binding on us. Would he have under the facts here a claim based on contract law to enforce the provisions of the contract that he originally signed?
Yes, I think that he would. I think, though, that there are some pertinent facts that might come out in an exploration of that actual scenario that could push it one way or the other.
And we don't have to reach anything beyond a waiver of rights, because the only thing that's being litigated here is a waiver of rights. So whether he was paying $39.99 a month or some other amount per month has nothing to do with this actual case, correct?
Yes, Justice, I agree with that. I think that with the appellate division's holding that there was mutual assent by conduct, that line of reasoning may be applicable to different parts of the contract that don't involve the knowing waiver of rights. But that with regard to the knowing waiver of rights, that you can't do that just simply by conduct without knowing that you're waiving your rights because you've never been shown the arbitration clause.
And specifically with regard to your argument that the certification from Altice was too generic and didn't say anything about the email actually being sent, are you pointing to paragraph 7 where it said when plaintiff ordered cellular service on November 20th, he received a receipt, see Exhibit 3. He also would have received a copy of the customer service agreement by email. And that does not say he also received a copy of the customer service by email, or he also would have received a copy of the customer service agreement by email, period. It was sent by such and such email address on such date, or even it would have been sent by such and such email address on such date, correct?
Yes, Justice. So I think that all of the certifications submitted by Altice is in the conditional, both the purported conversation with him at the point of sale and also the question of whether the email was sent. I do think that other cases, for example, SSI, which I know was in the respondent's brief, those cases involved people who were testifying not as to necessarily personal knowledge that the actual document was sent, but they had personal knowledge and relayed personal knowledge about what the habit or the routine was. And both the knowledge as to whether it was sent and also knowledge as to whether the routine or habit, what it is, and whether it would have been followed here is lacking.
What's the appropriate framework for a court to analyze this kind of dispute? What, if any, burden do you have in coming forward? And what burden does your adversary have?
Yes, Chief Justice. I think that one of the reasons that this case proceeded the way it did was because the framework wasn't entirely clear that we were proceeding under. I think that Guidotti is probably a good framework to start with in terms of burden shifting and who holds what burden. I think in this case, though, we don't get to the point of Mr. Fazio having to raise a disputed question of fact because the facts that Altice came to the table with are not enough to show a prima facie case that a valid arbitration clause was entered into.
What about the retail installment contract that he did sign about 5 days after he purchased the service plan, when he purchased the phone? It points out that there is such a thing as a binding arbitration provision, and it even tells him where to find it. Can you address whether that document itself in any way shows mutual assent?
So I would say we don't know if we don't know whether the link that was provided on that document actually led to the terms of service. There's no evidence on the record concerning that at this point. I would say that with regard to the retail installment contract, the notice of arbitration provision can't substitute for an actual arbitration provision, specifically here, especially because we are talking about a law against discrimination cause of action, and there's nothing in there about waiving statutory rights concerning the law against discrimination. And I was going to say something else, but it slipped my mind.
For him to see the actual arbitration provision, he has to go to a website, click on that website that's in paragraph 9 of the retail installment contract, is on page JA19. Click on that and then search for the binding arbitration provision.
Well, I mean, that is what the receipt says, but we don't know if it actually led to the binding arbitration agreement.
But you're not saying that there's any that an arbitration agreement is invalid if the way that someone gets to it is through a link. In today's business world, particularly in the employment context, it's prevalent to use email with links as a way to communicate with employees, is it not?
I don't know that I'm saying that, because I do think that the law requires a knowing waiver. And I'm not sure that simply providing a link to someone would be sufficient notice under New Jersey law, but I don't think that I don't know that that's been decided yet.
Here, though, we're talking about a printed receipt that said, in theory, review your terms of service at alticemobile.com/legal/terms and policies, right?
Yes, Justice. It does look like a printed receipt that somebody would have to go to a URL and type it in to try to get to it.
So your point is just that as for that printed receipt, it wouldn't give anyone knowledge of anything.
That is true. He could not click the printed receipt. Yes, Justice.
And paragraph 9 of the retail installment contract sends you to the website for Altice, not to a particular document.
Yes, it's one of the issues in this case that we do think has sort of affected whether there could have been a knowing waiver is the various terms and links that were provided. For example, in one place at the bottom of the receipt is referenced as terms and conditions. Altice is also referred to it as a service agreement and also a customer service agreement. And I don't think it's necessarily clear actually what any of those links are going to, particularly at this point in time, as it's not in the record. And yes, Chief Justice.
Let's talk for a second about if we don't agree with you and we think that Altice did enough to establish a rebuttable presumption. Let's talk about Mr. Fazio's affidavit. In that case, would you agree that Mr. Fazio would have to do something, or couldn't just not respond, or couldn't just say, I don't know, or I can't find it?
Well, I think that if this court said that Altice had done enough to establish a prima facie case, and under some sort of framework like Guidotti, the burden then shifted to Mr. Fazio, I do think that he's raised disputed questions of fact here that would have warranted either discovery or an evidentiary hearing for fact finding. For example, in his certification, he did say that he would not have assented to these agreements. He did search his email. Mr. Fazio doesn't have the personal knowledge to be able to say they never sent that email. So that's just not a position that a customer could ever take, because they don't know if a business followed its business practice in any particular circumstance.
So I'm clear, the answer to my question is yes, that Mr. Fazio would have to respond somehow if they had met the rebuttable presumption. They made a prima facie case, right? And I gather that your point is his response was sufficient to satisfy however that burden had shifted to him, because not only did he say, I don't have it, he said, I don't have it, and I've looked for it, and I can't find it, right?
Yes, Justice.
And he actually says more. He says, I looked for it, I can't find it. But actually, when I looked, other Altice emails came up, but just not this one, right?
Yes.
Couldn't Mr. Fazio have brought someone in, a technician in, to do a search of his computer and say, I've searched the computer and that email never arrived here? And isn't there a gap between Mr. Fazio saying, I looked at it and couldn't find it, although I found others, and someone who is sort of a more independent third party with more credibility coming in and saying, I ran a review of Mr. Fazio's computer and it's not there?
I think that would certainly be possible, but that would be a very high burden to put on customers, simply to discover whether or not their cell phone company actually did send an email that they said they had sent, which is why I do think in this case, to the extent that there is a burden shifting framework that would be appropriate here, that Altice just didn't overcome that initial hump of
In
showing.
discovery, even on a relatively straightforward and simple case like this, it's proper discovery for them to say to you, as you could say to them, produce all emails, including, your inbox, your deleted, your junk, your name all possible folders anywhere in your computer, to or from Altice. That's a valid discovery request, is it not?
I think it would be in some contexts, but I think that if a company is saying, this is our practice, we bind you to this arbitration clause by sending you an email, that they have the initial burden to make that showing before putting a burden on.
I'm talking about a discovery situation. You could ask them to produce anything they have remotely between them and Fazio. But when you're saying it's too high a burden to ask Mr. Fazio to do more than simply just look at whatever it is he did. I don't know what he did. I think you're being candid with us that you're not 100% sure what he did. He may have just looked at what's currently on his screen, and things may be just simply not there anymore for one reason or another. It is a valid discovery request to ask for documentation to the extent that it exists. Is it not?
I think that it would be a valid discovery request to seek documentation if Altice put forward enough of a prima facie case to say there is an arbitration clause that was present here.
And that's because they filed a motion to compel arbitration. And so in order to get anywhere on such a motion, your point is you shouldn't have to file discovery requests against them. They should just show that there was some sort of mutual agreement to arbitrate. And if their allegation is that it was created by an email having been sent, then they should show that the email was sent.
Yes, Justice.
Can I come back to an earlier question? What is your burden? You mentioned the Guidotti framework. What is your burden?
So I think that if Altice had made an initial showing that there was this arbitration clause, that they had followed the process to properly bind Mr. Fazio to the arbitration clause, then under that framework, Mr. Fazio would have had to raise a question of disputed fact. I think that if that framework were to proceed to that step here, he did do that by searching his email and not being able to find it, and also affirmatively swearing that he did not intend to assent to any arbitration clause wherein he waived his LAD rights. So I think that that's probably where it would have been, and then maybe under an evidentiary hearing, or on the paper, as the judge could have made findings of fact, or I'm not sure if a jury would be appropriate for fact finding at that stage.
Is it his position that he didn't get the email?
Yes.
So he's making a representation that he did not get the email.
So it's just a very hard thing for an individual to say something like that because they don't know what a company did. It's difficult for someone to say, I never got this email was never sent to me, because maybe it got caught in a spam filter. There's all sorts of things that could have happened in between. But Mr. Fazio has no evidence of ever having received the email, and he did look for it.
But he could have answered some of those questions. If he had somebody come in and look and help, he could have answered whether it went to a spam folder. Or actually, to Justice Patterson's question before, he could have answered in his affidavit whether he searched in a spam folder. He could have gotten out in front. We're in a gray area, right? And when he could have gotten out in front of that by doing much more than he did. And so we're trying to understand what did he have to do? What would he have had to do to meet his burden? And we don't know now. From his affidavit, we don't know if he looked at his spam folder. We don't know if he looked outside of his inbox.
Well, I don't think that Mr. Fazio was under the obligation to rebut an assertion that was not supported by evidence. I think that puts too much of a burden on him. Altice is saying that this email exists, then it's Altice's burden to prove that the email exists, not Mr. Fazio's burden to prove that it doesn't exist, because that's a very hard thing to do ever.
I thought you were saying that Altice never even said that the email did exist.
They
I thought
didn't.
you were pointing out that the problem with the certification from Altice is not, X email was sent on Y date, and then they didn't attach a physical copy of the email. It's just that it didn't actually say any email was ever sent ever. Didn't provide any details about any email. It just said he would have received, or an email, I don't remember the exact language now, but would have been sent or would have been received.
Yes, that's true. So I think in this
It
case,
says he also would have received a copy of the customer service agreement by email. So it doesn't even say we would have sent it, or X email would have sent it, or in our business practice, we sent it. It just says he would have received it.
yes, Justice, that's correct. So it really isn't even as strong here, whereas Altice would have said they sent an email and had to produce it. Here, they really didn't even represent that the email was sent.
Counsel, is your ultimate recommendation that we remanded to apply the Gaddafi standard and have the fully fleshed out hearing so all of this can be worked out?
No, Justice, I don't think that that's necessary in this case, because Altice already put their case forward. They submitted the evidence that they have. I think that remanding back down for discovery isn't warranted, because Altice didn't meet that initial burden of establishing a prima facie case. And it would be a second bite at the apple that would just consume judicial resources. I think the case should be remanded to proceed.
If this were purely on a motion to dismiss, sometimes courts grant motion to dismiss, they grant motions to dismiss, and appellate courts say this is not an appropriate motion to dismiss, but it needs factual determinations, and you can proceed either to trial or for summary judgment after there's been limited discovery on this issue. Why is that not a way to get at the ultimate fact here of whether or not this email ever existed?
Well, I think that would be one way to get at that ultimate fact. I just don't think it's warranted at this point, because Altice didn't meet their initial burden. We were in court in 2022. They made a motion to dismiss. They supported it with affidavits. They supported it with a lot of extraneous evidence that was outside the complaint. They made their motion, and that was the evidence they presented.
And if they presented, I'm sorry.
Go ahead.
If they presented in the affidavit, it is the routine business practice or habit of Altice to email the terms and conditions every time someone comes in to either buy a service plan or a phone, then they would have met their initial burden, are you saying?
I think that they would have had to present a witness who had actual personal knowledge of the routine and the habit.
Right.
And I think that as a practical matter, it would have been good to have an evidentiary hearing where that witness could be cross-examined.
Right.
Other questions, anyone? Anything you'd like to add, counsel?
No, thank you, Justice.
Thank you. Mr. Barrett.
Thank you. I would like to present two basic points to the court today. The first is that the association's position is under the facts presented, where no terms of an agreement were presented to a consumer before they finished a purchase. An agreement to arbitrate or waive any statutory rights could not be reached. Sending an email after the agreement has been reached without some evidence of actual assent on the behalf of the consumer is not enough. And second, that the Altice did not meet its burden of presenting habit evidence in support of its motion to compel arbitration. The affidavit provided presents no information about the specific employee who had a conversation with the plaintiff or his habit or practices, and provides no information about the business practices specific to Altice in this situation.
Mr. Barry, is this two-stage process that we see here something you've seen in other settings?
No, Your Honor. I was actually struck by this when I reviewed the case, because what we have is a consumer who walked into a store to spend $10.16 on a $20.
All right.
We have a consumer who walked into a store to spend $10.16 on a $20 a month cell phone plan. When he walked in, he wasn't handed a physical copy of terms of a customer service agreement. It wasn't laminated to the desk where he could look at it if he wanted to. It's a cell phone store that sells devices. They didn't spin a tablet around to let him scroll through a customer service agreement and check a box to say that he had read and understood the terms. Instead, what we have is a consumer who walked in, apparently spoke to a customer service rep, was told there are some sort of terms and conditions that might apply, was handed a single page physical receipt at JA-22, and walked out of the store that day without anything further. The only piece of evidence in this case showing that a customer service agreement may have been referenced in this whole transaction that day is an extremely small print on JA-22 that says, review your terms of service on alticemobile.com/legal terms and policies. So, I was struck in this case because the court has been clear. You need clear and unmistakable evidence of an agreement to waive statutory right. But in particular, in consumer contracts, this court has looked to the Plain Language Act in Altice, in Morgan versus Sanford Brown, in Kernahan versus American Home Warranty. And Section 2 of the Plain Language Act is clear that a consumer contract has to be written in simple, clear, understandable, and an easily readable way. Providing a printed link that somebody has to go home or find a device that they can key into a web browser is not an easily readable way.
And just to go back to my question, is this something that is happening in that industry or that you've noted? I know you can't represent.
It's not, Your Honor. And actually, one of the cases cited by a defendant shows it's not even happening across their company. Lopez versus Sequel Communications, which was cited in the supplemental briefs, there was an affidavit in that case for an Altice subsidiary, which they sent 2 emails before installing home service agreement. When the service tech came to the person's house, they handed them an iPad. Altice was able to show the slides that the customer interacted with, explaining arbitration, explaining the agreement. They had to click that they read and understood before the installation could occur. And then there was subsequent conduct, but it's really remarkable how different this case is from that case involving another Altice subsidiary. This is really sort of an outlier that we don't have a consumer contract being exchanged. It's really a pretty basic requirement for businesses trying to do business with consumers in New Jersey is to hand them a copy of the terms that you believe you're binding them to in order to hold those consumers to that contract. And I'd also like to point out that, I referenced Section 2 of the PLA. Section 10 of the PLA was also referenced in Morgan and Kernahan. And in those cases, the court talked about how you can't slip secondary portions of the agreement that are different from the main agreement in small font. You have to provide them with equal prominence, the main terms of the agreement. This receipt shows the main terms of the agreement are to supply cell phone service at a certain price, and in exchange, the plaintiff or consumer is agreeing to pay a certain amount. You can't then, in a small font, in a way that can't be accessed through the receipt itself, add additional terms that are completely different. I mean, we're talking about, this isn't even we agree to arbitrate contract claims. This is we agree to arbitrate every statutory tort, every claim that you could have against Altice. I mean, I don't know if Altice could have an installation van hit Mr. Fazio down the street 2 years later. And technically, I think we're arbitrating this case if this arbitration clause is enforceable. It's really a remarkable thing to not give him a copy of that at the time you're binding.
If the plaintiff had received the service agreement and had not opted out in the time frame, would he be bound by the binding arbitration?
No, that could have happened, but it wouldn't have happened under this case. So the retail installment sales contracts is not specific enough to alert a consumer what arbitration is and what it involves to put them on notice that they should be looking further as to what that means for them.
What about the customer service agreement, though? I thought Justice Bishali was asking, had he been handed a copy, not asked to sign it, would that be enough
So
of the customer service agreement, not of the RIC?
So the customer service agreement, I think the language in the customer service agreement is sufficient if there was some affirmative assent on the behalf of the consumer. So if you had handed it to Mr. Fazio and then he paid and walked out with his service, that's a manifestation of assent. That makes sense.
What if he was not handed it, but it was emailed to him and he did receive the email?
I think the law needs to be that he gets to review those terms before he enters into the agreement. You can't enter into an agreement with secret terms that a consumer then has to discover later and figure out whether he needs to go back in, eat the money for whatever time period he has this service because he's not going to get a full refund. Again, it's a pretty basic requirement for businesses in New Jersey to provide.
But under Justice Bishali's example, that if they emailed in the store, if they said, you're going to get this by email, and check your email, and then he either did look at it or didn't look at it, but had it on his email and could have waited a day to sign, why wouldn't that be binding?
Yeah, as long as the email came before the transaction was complete, I would agree that that would be a sufficient way to, as long as you had proof that the email was actually sent and that the email was, I mean, as long as that was what happened, then yeah, I think you could do that. The problem becomes when you have a completed contract and you add terms later without requiring some affirmative consent on the behalf of the consumer. I would also just note that the evidence is contradictory. The address on JA 22 provides a website that says /legal terms and policies, but the customer service agreement at JA 23 says that the customer service agreement is at terms and policies /customer service agreement. So it's not even clear that if Mr. Fazio had had the incredible wherewithal to look at this receipt, go home to his computer, key in this website address, that he would have even seen the customer service agreement or something else. And I'll also add that, you know, the Chief Justice pointed out that the Retail Installment Sales Act has yet another website address at paragraph 9 on JA 19, which appears to point to a privacy policy, but they point to a completely different website address in that agreement. So there's 3 separate website addresses being provided to a consumer. It's all really a confusing sort of mismatch. And I'll briefly just touch on.
Counsel, before you move on, when you said as long as he got the email before the transaction was complete, do you mean the transaction on the 20th or the transaction on the 25th?
The 20th. As long as before. So, for example, if I made a transaction by telephone and I decided I wanted to buy something, I have done is you pick up the phone, you call, you say, I would like to buy, I don't know, 10 basketballs. And they say, okay, we're going to put through your order. We're going to send you a text message right now with a link to our terms and conditions. Take a second to review it. You can scroll through it and then just let me know. First, it's good because it's identity protection. You make sure that you're not engaging in a fraudulent scheme to sell to somebody who is using a fake credit card. But second, it allows a consumer to review the terms of the contract before they complete the transaction. I've also had that done, if not by text message, by email. And I think that's a reasonable way in the way that our world operates to allow businesses and consumers to complete contracts.
It wouldn't be a defense if you just happened to be so busy playing basketball, you weren't looking at this terms and conditions. If you had it, that would be sufficient.
Correct.
On text
It's
or
not a
email.
defense that you didn't choose to read the terms of an agreement that you were provided, but it is a defense that you were never provided with the terms of the agreement at the time the contract was formed.
But here you're going one step further and saying, even if he had gotten it, the transaction was done, so it didn't matter. He couldn't have sent because he received it later,
It's
if
not-
he received it.
Yeah, I don't think I'm going one step further. I think the terms have to be provided at the time of contract, or if you're going to provide them afterwards, require some affirmative proof of assent from the consumer. So,
Right, so they could send the customer service agreement over email afterwards and say, you must click at the bottom of this email to show that you agree to the CSA. And then you'd be fine with that regardless of whether they had actually read it or not. As long as they click, that's enough to show mutual assent.
that's basically skews, is that you've seen the arbitration agreement, you've seen the terms, you've clicked the box acknowledging it, and you say that by continuing the service, you're agreeing.
We're not
You're-
even seen, but given the opportunity, it was sent to you, regardless of whether you chose to look at it. Is neither here nor there, as long as you click on the box.
Correct. That, yeah, you agree that you received the email, whether you chose to read it or
I
not.
think the acknowledgement was having gone as far as, if I remember the facts of SKUs, if you got to the acknowledgement box, you had opened
Mhm.
a
Yeah, and
web address that had that in.
this comes up a lot in click wrap agreements, which are regularly enforced. And a lot of those have a link that you click and it forces you to take a pop-up and scroll through the terms and conditions. I don't know that many people actually read them, but it's entirely possible to do. It's not a high burden. Businesses do it every day.
I don't want to get into a debate about SKUs. My recollection is that it did not have the word agree. It only had the word acknowledgement.
That is actually my recollection too. We agree on that.
I agree as well. I think I misspoke. Briefly, I just want to address the habit evidence, or the quote unquote habit evidence under Rule 406. This court should decline to address SSI because the evidence that's presented does not rise.
I'm sorry, this court should,
Decline to revisit Rule 406 and the opinion in SSI because the evidence provided simply doesn't rise to the level of habit evidence. So I think there are two separate pieces of evidence that are purported to be provided here. The first is what a customer service rep would have done in store, and that is have a conversation with the consumer. I do a lot of class action work. And I will tell you that oral representation cases are impossible to do as class actions because you can never say that in every case, a customer service rep said a certain thing to a consumer. It's impossible to do as a business to say all of our customer service reps always discuss our service agreements. If you wanted to try and use habit evidence, you would need habit evidence specific to the actual employee who had a conversation with Mr. Fazio at the time that he entered to say, this was his regular practice. Just like we allow doctors in mass tort cases or personal injury cases to say, I always discuss the informed consent with my patients, the risks and rewards of surgery. It's specific to the doctor.
But the habit evidence here includes the emailing. So that's a little bit different than simply relying on an oral representation.
I agree. There's two separate pieces of habit evidence. I think the employee evidence is one, that the email evidence is one that could be proven through habit, I think. But the evidence supplied is insufficient to meet the burden under 406. So 406 requires that you provide specificity as to what basically the inputs and the outputs, what circumstances happen and what your almost automatic response is to those circumstances. What we don't have here is, when does an email get sent? How long does it take? Is it automatic? Does it require input from a customer service rep? Instead, the only thing we have is in paragraph 7 is testimony that the plaintiff would have received an email. An impossible thing for a person with Altice to testify about with knowledge.
What about paragraph 11?
So that's actually a quote from Exhibit 2, which I believe is the retail installment sales agreement, that they're actually just pulling a quote from Exhibit 2. I apologize, the appendix, I think, lost the order of the exhibits attached to that. So I don't think that that's actually any evidence other than he's rewriting something that was already written by Altice. I think in order to provide habit evidence, there would need to be evidence that the company has a policy and a procedure. I mean, when you look again at the Lopez case, evidence that emails were automatically sent to customers, there are screenshots of emails, there are screenshots of the iPad screen that customers were shown and had to scroll through. So even if this court were to want to get to SSI, the cases cited actually do provide supplemental evidence. They provide additional evidence besides just the say-so of an employee. They provide the actual copy of the pro forma email that would have been sent, a copy of the screen that a customer would have seen. So they do actually talk about supplemental evidence.
So if the salesperson had provided an affidavit that said this was my normal course, was to describe the CSA prior to the transaction, you're saying that wouldn't be enough? Would that sell you?
I think that if the customer service rep testified about that, that might qualify as habit evidence. I don't think it would be enough to support Altice, Morgan versus Sanford Brown, or any of the other cases for the waiver of a clearly established legal right.
What if the customer service rep said, I specifically remember explaining the CSA to this person who bought the phone, or this is the service plan?
I think if we were going to get into hypotheticals like that, the customer service rep would have to be able to testify that he specifically described the rights that that Mr. Fazio had and the rights that he was agreeing to give up by entering into the customer service agreement.
Unless he testified that he gave him a copy of the agreement or something like that, or that he had clicked a copy of the agreement.
Oh yeah, I mean, this case wouldn't be here if they just handed Mr. Fazio a copy of the customer service agreement at the time that he bought his service.
And in effect, your point is you'd have to have a representation they effectively read paragraph 25.
Correct.
Or received paragraph 20.
Right. We're talking about the oral conversation that takes place in the store, not clicking or signing after.
Right. If a customer service rep could say, essentially, I read paragraph 25 to Mr. Fazio before he completed his transaction, I think that's pretty good evidence.
Further questions, anyone? Thank you. Ken.
Thank you very much.
Wire?
Good evening, Chief Justice Radburn, and may it please the court, I have to apologize first because I brought my phone up here because with my old man eyes, I can't read some of these provisions in the appendix. So if you give me questions about it, I'm going to have to use that like I do in a restaurant to read the menus. But I think the significant thing here is that we've got a telecommunications company that is saying, we send an email to the guy, but we can't find the email. And we can't find anybody who actually says they sent the email. And we can't find anybody who actually says that they explained anything to him.
But none of it, they don't say all that.
Well, they don't have the email. And we're in the third year of this litigation. The case was filed in 2022, Justice Patterson. By the way, I recognize what Your Honor is saying about the record. The record in this case is very threadbare. I agree with you on that. And I understand why the court's inclination might be to simply say, well, we don't have a full record here, so how can we fully resolve this? I submit that the defendants picked their poison by filing a motion to dismiss on the record that they had, and they have to live or die on that record.
Well, motion to dismiss are generally filed based on only on the complaint for discovery.
Right. They developed a record based on this affidavit submitted by an Altice employee. But
It was actually a motion to compel arbitration, right?
right.
And then a motion to dismiss, or was there a motion?
Well, most of the motions to compel arbitration are either resolved as a motion to dismiss or as a motion to stay the proceedings pending arbitration. But under the appellate rules of this court, it's effectively the same thing, which is why we're here as why Mr. Fazio could file an appeal as of right. But they chose their way of proceeding, and their way of proceeding was in the absence of any evidence that the email was sent, simply saying, well, we would have sent the email. I totally recognize that, again, the record here is rather threadbare, but there simply is no evidence that this contract where the arbitration clause exists was ever actually provided. It's actually not even clear from the record whether Altice is saying we gave it to him in the store or we emailed it to him or we did both. And certainly no explanation of given when it was sent or who sent it or any other kind of details that we have. This is really quite different from SKUs, where there's no question that the employee clicked on the little link that then described the arbitration agreement. I mean, the employee didn't say, oh, no, I never clicked on that, or I never saw that, or that never happened. This is a case where the consumer is saying, I don't know what you're talking about. I did not waive my right to a jury trial. He says that unconditionally. I did not waive my right to a jury trial. And I think that's one of the points that's important raised by the questions by Judge Fashali, which is that it's not just a question of sending it to him. There has to be assent. It can't be the case that there's a binding contract with assent. And I think that as far as what the framework is for where the burden is on a party that wants to enforce a contract to show all the elements of a valid contract, one of which is mutual assent.
Same question as I asked Mr. Barry. Is it your view, Mr. Dwyer, that this is a unique or close to unique circumstance in your experience, obviously?
Oh, yeah, very much so. And again, I just don't understand why Altice either doesn't have a system in place to actually validly show mutual assent, or just can't show it in the facts of this case. The fact that they can't, after 3 years of litigation, come up with the email that they claim would have been sent, I think should be pretty disturbing to this court, especially since the standard for waiver of a statutory right and the right to a jury trial is clear and unmistakable. There's not clear and unmistakable evidence in this case of a waiver of a statutory right, not by a long shot. The retail installment contract, I think that Mr. Fazio absolutely did sign, completely undermines their argument, because the retail installment contract does mention arbitration, but expressly states that it applies to the agreement and the terms of the agreement, and says nothing about applying to statutory claims. And under Garfinkel, which has been the law of the state for, I don't know, 25 years, that means that's not a valid waiver of the right to a jury trial under the LAD. And
In the employment cases that you're an expert in, what's the typical scenario today as to how this type of waiver is?
Yeah, I mean, so
I assume most of it's digital in some
right.
sense.
Employers have got, guys like me go and find ways to mess up the arbitration agreements, and then they go back to the drawing board and tinker with it to make it better.
Well, then everybody's making a contribution.
And that's what they've been, that's the little battle, that's the little game we've been playing for 25 years. So the employers who want to have enforceable arbitration agreements have gotten really quite good at it. They do make sure that there is a paper trail or a digital trail to show that the thing was signed. I had a case relatively recently where we sued and the employer said, oh, your guy had an arbitration agreement. And I said, oh, I went to him, he said, no, I didn't have any arbitration agreement. What are you talking about? I never signed a thing. And they showed the onboarding package that he signed, and lo and behold, it was there. I don't think that's a particularly high burden to place on corporations like Altice to just keep your record straight. And again, I think that Counsel for NJAJ is right. When we're dealing with a consumer contract, an individual consumer is one who has the burden. Now, I would agree with you, Chief Justice Radner, if they did come forward with some evidence that was persuasive evidence, carry their burden, that showed that they actually sent him an agreement, not after the point of purchase, but at the point of purchase, where he's waiving a right to a jury trial, then yeah, I think he would be obligated to come forward and say something concrete like, absolutely that never happened. I was never told that. I never got that email here. Here's my email account. Go ahead and search it forensically. There's nothing there. But I don't think we even get to that at this point, because I don't think they've even carried their initial burden of establishing the basic element of any contract. And what the FAA always says, right, is arbitration agreements should be treated like all other contracts. I agree. With all other contracts, you don't have a valid contract if you don't have evidence of mutual assent. And it's obviously lacking in this case. They can't even show that it was sent to him, let alone that he agreed to it via any of the methods that are described in the contract. They can't show that he agreed to it. If he didn't agree to it, then there's no enforceable contract here. And I really think that it's honestly that's and the receipt doesn't, that's on J48, that doesn't say anything about arbitration. It doesn't say anything about arbitration at all. So I just don't understand the defendant's argument. No one's saying that Rule 406 doesn't exist or anything like that. But Rule 406 is not dispositive of this case on the particular facts of this case. It just isn't.
Questions, anyone? Thank you.
Short and sweet.
Stone.
Thank you, Your Honors. Altice's customer service agreement contains an Altice compliant arbitration clause. There's no question about that. The question presented is whether Altice proved that Mr. Fazio agreed to the customer service agreement through evidence of Altice's routine practice of emailing the agreement to its customers without additional evidence that it was emailed to Fazio specifically? The answer to the question presented is yes, for several reasons. First, the question presented is answered by the text of evidence rule 406. Under that rule, evidence of a routine practice is not just admissible evidence. The rule says that evidence of a routine practice is admissible, quote, to prove that on a specific occasion, a person or organization acted in conformity with the habit or routine practice. In other words, evidence of Altice's routine practice of emailing the customer service agreement to its customers is evidence that it was emailed to Fazio. And the rule says that that is so, quote, whether corroborated or not. Rule 406, like any rule of evidence, is subject to the witness or affiant's personal knowledge, the affiant's competence to testify. Now, plaintiff and amici have argued today, some of them have argued, that the evidence doesn't satisfy Rule 406. That was never raised before today. It was not raised at the trial court or the appellate division in any of the briefs in this case, and it is not part of the question presented. To the contrary, the question presented presumes that it was emailed as a routine practice. Had counsel raised below some question about whether the evidence under Rule 406 satisfied Rule 406 and complied with the bona fides that counsel says are required by Rule 406, the trial court and or the appellate division could have decided it does satisfy Rule 6, it doesn't satisfy Rule 406. That never happened. The question presented and the facts as it comes before this court today and the findings made by the lower courts is that the evidence established a routine practice. Now, one could theoretically question in any case whether that evidence was satisfactory or not. That never happened, and it's not part of this case, and it should not be part of this appeal. Numerous federal courts have held that evidence of such a practice is sufficient to prove a contract without corroborating evidence that the practice was followed on the occasion in question. And I should add that plaintiff's supplemental brief at page 1 acknowledges that this case is not about the admissibility of the Rule 406 evidence. Counsel specifically said in that brief at page 1 before this court, admissibility was not an issue in this case at any level. So the evidence submitted under Rule 406 is in. Second, the evidence of Altice's routine practice of emailing the customer service agreement to its customers is not the only evidence that Fazio knew about the customer service agreement before signing the retail installment contract. When Mr. Fazio signed up for the cellular service, he received a document, JA-48, that said, quote, a copy of all documents and agreements will be sent electronically to the email address you provided during the account creation. He also received a document, JA-22, that said, quote, review your terms of service at, and then it provided the link which we've discussed. 5 days later, Mr. Fazio bought a new cell phone. He received and signed a retail installment contract for that phone. That contract, which he signed, said, quote, the arbitration provision and other provisions of your service agreement are incorporated by reference in this agreement. That contract also said, quote, this agreement is subject to a binding arbitration provision. A full copy is contained in the service agreement, and the terms are incorporated by reference. So when Mr. Fazio signed the retail installment contract 5 days after he signed up for cellular service, he knew that the customer service agreement had been emailed to him. He knew that the customer service agreement was available to him online, and he knew that the customer service agreement contained an arbitration clause. That is prima facie evidence of mutual assent, of a contract. At that point, the burden shifts to Fazio to establish something contrary, or in technical terms, to establish a question of fact. fact as to whether there has been a contract to which the parties have assented. Mr. Fazio does not deny receiving any of the agreements we discussed. He does not deny that he received the retail installment contract, because he can't, because he signed it. He does not deny receiving the other two documents I mentioned, JA 48 and JA 22. And in particular, he does not deny receiving Altice's email, which had the customer service agreement attached. What he says is only that 3 years after those events, he can't find the email. He did a search himself and he can't find it. That is not a denial of having received the email. The cases that talk about the burden on a party to establish that something did not happen are very clear. The plaintiff, Mr. Fazio in this case, is required to make an unequivocal denial. I reference, for example, the Second Circuit's decision in Doctors Associates versus Jabush, 89 F3rd at 109. The court said to establish a genuine issue, entitling a party to a jury trial, an unequivocal denial that the agreement to arbitrate had been made is needed, and some evidence should be produced to substantiate the denial. The Seventh Circuit said in Tinder versus Pinkerton, 305 F3rd 728, Tinder's only evidence that she never received notice of the program was her own affidavit in which she avers that she, quote, does not recall seeing or reviewing the arbitration program brochure. This does not raise a genuine issue of material fact. So the burden is on Fazio.
Leaving aside for the moment burdens, and I don't in any way denigrate the importance of burdens in this process, but, and I'm not asking you whether this is true, but if your client has a sent email or some other indication of sending in whatever technical form it may be, wouldn't that have ended all this a couple of years ago?
Yeah, in that theoretical universe, if we had produced the email, if we had the email, we would have attached it. But it was never asked for. Putting counsel's off the record informal contact with counsel, which I can't speak to, aside.
There's no discovery.
There's no discovery.
And your client was never in the position that parties are in all the time of saying, we better check for this sent email because we have a discovery request for it. And then lawyers get to work and clients get to work and you find out whether it exists or not.
Correct. And there is no discovery. And I'll talk about
But you are filing
discovery.
a motion to compel arbitration, correct?
This is a motion to compel, correct?
So why would you need discovery to produce an email from your own client?
Presumably, if they had it, they would have attached it. But I don't know that for a fact because it's not part of this record. We don't know why it wasn't attached. No record was made of that. But I will say this. A party is not under an obligation to retain all emails for all time. It is also not feasible for all parties to retain all emails for all time.
But
Indefinite.
If you get a discovery request and there's been a document retention policy that calls for emails to be purged every year to whatever it may be, then that's part of your response to the discovery.
Correct. And I will say, again, it's not part of the record, so I don't know what that retention policy is for purposes of this record, but I will point out the complaint was filed in October of 2022, which is more than 3 years after the events in question. So that may tell us why the email was not attached to Altice's motion.
Mr. Stone, I'm not in any way questioning your representations to the court, and I'm not about to with the following question. Did you ask if the sent email exists, and do you know whether it exists?
My understanding is that it does not.
Thank you for your candor.
You're welcome. I want to talk just for a minute about discovery.
Sorry, before we get to discovery, and regardless of whether the actual email was attached, I understand your point as to why it may or may not exist. I'm looking at the affidavit from Dency Gonzalez, the Altice Senior Director.
Yes.
Which part should I look at to find where it discusses a routine business practice and exactly how it was routinely undertaken?
It is discussed in paragraph 3, paragraph 4, paragraph 7, paragraph 11, all of those paragraphs talk about how the process works generally.
Correct, but in an extraordinarily generic way, right? So paragraph 3, a customer would either be requested to consent to the customer service agreement verbally or in writing, depending on the manner in which they activated their cellular service. Does not say if they activated it in person, then they would have to consent verbally. If they activated it over the phone, then they would have to consent in writing. Nothing like that, just extraordinarily generic. Could be A, could be B. We have no idea.
And implicitly, Your Honor is questioning whether that satisfied the standard under Rule 406. But as I said, nobody questioned that below. The trial court and the appellate division were fine with that evidence. And even if we sit here today and say, well, you could have done it this way and it could have been more specific, nobody did. And it's not part of the question presented. It was never briefed by anybody. Nobody before today suggested that 406 wasn't satisfied.
Counselor, at the time of this, how long was the company's document retention policy?
I'm sorry, I couldn't hear you, Your Honor.
At the time of these events, how long was the document retention policy?
Altice's, I do not know.
When you say it wasn't part of the issue certified, I'm looking at the order that granted the petition for certification. And it deals with establishing mutual assent through a business's practice of sending a service agreement without proving that the practice was followed as to the plaintiff. So we are on notice that we're dealing with whether 406 can be used to prove that Altice acted in conformity with its business practice. What I'd like to know is what was its practice and where in the record do I go to find that?
I understand your question, Your Honor, and I think I answered in response to Justice Weiner. After those paragraphs collectively in that certification address what Altice's practice is.
So we discussed paragraph 3. You also said 6?
I said 3, 4, 7, and 11.
So 4, the customer service agreement is also provided to the customer through a link when they receive their receipt following the placement of their order for cellular service. And we've seen the receipt here and we have read that it says, doesn't say anything about arbitration, but it says review your terms of service at altice.com/legal/terms and policies. That would not be sufficient in this case to show mutual assent to an arbitration agreement, correct?
By itself, if you simply sent the customer a link to the arbitration clause, well, in this case,
It doesn't appear to be anything sent. It's just a paper receipt that at the bottom says review your terms of service at alticemobile.com/legal/terms and policies, correct? Or are we talking about something else?
No, that is one of the documents. You're looking at J22, I see.
And that's number 4. That's what's referenced in number 4, correct? Because we're talking about a receipt. Or we're actually asking because we don't know what these are referring to. So if it's not JA22, I completely understand that, but I'm asking what it is.
I don't know specifically if paragraph 4 is referring to JA22 specifically, but we do know that JA22 does contain that link.
Okay, so now paragraph 6 you mentioned, right? Well, oh, sorry, not 6, just 7?
7.
Okay. Well, when plaintiff ordered cellular services on November 20th, 2019, he received a receipt, see Exhibit 3. I think that's JA22, but open if
It
that's
may
wrong.
also be 48, I don't know.
And he also would have received a copy of the customer service agreement by email. That seems like the only sentence, the most important sentence here, but it does not say we also send a copy of the customer service agreement by email, or such and such human would have sent a copy of the receipt by email, or a copy of the CSA would have been sent automatically by email when he clicked X. It is just written in a very generic, he would have received who knows from whom, who knows when, who knows in what form. It's very hard to understand this as evidence of a routine business practice because it doesn't actually say anything that Altice is doing. It just says, in theory, he also would have received it.
I think it is not a surprise to anyone here that the trial court and the appellate division accepted this language, particularly the language in paragraph 7, as precisely the language satisfying evidence of a routine practice under Rule 406 without question from anybody, including plaintiff. Nobody questioned that until today. So yes, it's not perfect. And had Your Honor been drafting the certification, it might have had some of the language you're talking about, and it doesn't. I concede that, but that doesn't mean it's inadequate, especially given it hasn't been challenged before.
So you're arguing that the only thing that is before the court is whether Mr. Fazio satisfied his burden. Absolutely nothing about whether Altice satisfied its own burden, despite how Justice Bashali just read the certification order?
No, I believe that Altice has an obligation to establish a prima facie case that the parties agreed to the terms that include the arbitration clause, and that exists through a combination of all of the evidence that I recited during my introductory comments, including the customer service agreement, the link, the email, and subsequently the retail installment contract, which Mr. Fazio received and signed, acknowledging the customer service agreement that's specifically referenced and incorporated by reference in a document he signed.
And that, sorry, you're referring to where it says a full copy is contained in the service agreement under the heading binding arbitration, which terms are incorporated by reference? Is that the RAC?
I'm sorry, paragraphs 1 and 2 refer back to the customer service agreement by specific reference.
And that was 5 days after he, in theory, received the customer service agreement?
Correct. It's also referenced obliquely in the end of paragraph 5 and in paragraph 7. It's referenced several places in the retail installment contract, but most notably in paragraphs 1 and 2, where it's expressly incorporated by reference, and then he signed it.
How does that comport with the requirements of Altice? Paragraph 2 seems to be the one that is most relevant. Is that sufficient?
I believe it is. I believe that Mr. Fazio was given this document, the retail installment contract. It says you received a customer service agreement, signed, and he signed.
You're referring to paragraph 2 of the retail installment contract?
Correct. And also paragraph 1, which also incorporates it.
Where does that identify the scope of the arbitration provision?
It does not. Nobody is arguing that the retail installment contract by itself has an Altice compliant arbitration clause.
And that turns on whether the customer service agreement was appropriately provided and reviewed by the individual.
Correct. Right. The opportunity to be reviewed.
Yeah.
I want to just say a couple of things about discovery, which has come up today. I don't know that discovery is going to be particularly useful. Discovery is designed to illuminate questions of material fact. The evidence that we've provided, that we've discussed today, of all of the documents, the customer service agreement, the retail installment contract, the two receipt, whatever those things are, J22 and J48, and Altice's routine practice of emailing the CSA to customers, all of that in combination more than satisfies Altice's burden of establishing that there was an agreement that included an arbitration clause. There's no discovery I know of that's going to change any of that. We might learn more about Altice's customer practice, but it's established.
What discovery might generate, you know, in a situation where you have motion dismissed tonight or there's no motion made, discovery happens, and then you're later at a later stage with a more of a factual record with the court is, for example, here's how we go about emailing. We get their email, we rely on the email they give us, that we do this, that, and the other thing. Here's our technical thing we do to send it out. And while we don't have the particular email today, because it's 3 years later, here's our document retention policy, which in the ordinary course would have ended up deleting this document. You know what I'm talking about.
I absolutely
You've done this
do.
a lot.
The only thing I would say to that, Your Honor, is I believe Altice has satisfied its burden, and therefore Altice doesn't need discovery, because if I'm right, then Altice has satisfied its burden of establishing a prima facie mutual assent. At that point, the question is whether there's any discovery that's going to change. In
Well-
theory, we might get discovery, as we've discussed today, about Mr. Fazio's denial of receiving the email. Yes, we could do that. The question is it necessary and warranted on this record? Is it a useful exercise if Altice has satisfied its burden of establishing a prima facie case? I would also point out,
We were to disagree with you that
Yes.
Altice had satisfied its burden. You also wouldn't need discovery to satisfy that burden because you could just submit a clearer affidavit, correct?
absolutely right.
Altice would never need discovery into its own practices. It would
Correct.
only need to just discovery into something that it itself does not control the information.
Such as whether Mr. Fazio's email account has a record of the receipt of the email in question.
Correct. And whether his inbox had been searched versus his trash container.
All of
I
that.
understand you have no control over that, but
Correct.
anything that's about whether Altice has a copy of the email or what Altice's precise business practice is, the email gets sent from X address automatically every time a retail sales agent presses Y. That's all within your control and you do not need discovery to produce any of that.
Correct. I would also point out, we're asking a lot of questions that I understand make sense in the context of this case. Those are questions that might have been asked below had plaintiff challenged the adequacy of Altice's Rule 406 routine practice evidence. As an adjunct to them not having challenged that evidence, they also never asked the trial court for discovery on those issues. You would think that if there was some genuine concern about whether Altice has such a routine practice, plaintiff would have said to the trial court, I would like discovery to illuminate the paragraphs of Altice's certification that you and I were talking about. That never happened. Not only didn't it happen below, no request for discovery was ever made, and I would argue therefore it's waived, but it's also forfeit because it was never briefed. No one ever said the trial court's judgment should be reversed because we need discovery. That never happened. And it's not appropriate in this context to be standing here saying Altice, that we should remand for discovery and Altice's judgment for arbitration should be reversed because we need discovery. Nobody asked for it. Nobody briefed it.
So no, go ahead.
Because it's my understanding that plaintiff is not asking for discovery. There's been a lot of discussion about discovery, but it's my understanding that they're not asking.
That's fair. Your honors are not subject to the forfeiture rule.
And we can decide this case on the record that we have before us and address whether there's sufficient evidence in the record to meet Altice's burden to show what its business practices are, right?
Correct. And conversely, that Mr. Fazio did not satisfy his burden of coming forward with evidence to the contrary because he did not issue an unequivocal denial of receipt of that email.
What do you rely on to establish evidence of mutual assent in this case? You mentioned earlier the opportunity to review. Is that sufficient without proof that the individual either acknowledged or agreed in some fashion?
I'm not sure I understand your honest question.
Is it enough to just send an email?
Well, in this case, Fazio signed a retail installment contract that refers specifically to the customer service agreement. So
That doesn't establish mutual assent.
the retail installment contract signature certainly does. He signed that contract, and by signing a contract that refers to the customer service agreement, we have both elements. We have an Altice compliant arbitration clause, and we have plaintiffs signing a contract that incorporates that document by reference. So as
And in
long
that-
as he received it,
in
we're
that-
done.
In that link, what does that link lead you to? Not today, but then. Doesn't it lead you to their general website?
Well, as we discussed, there were a couple of different links, and it's not part of this record, so I can't speak outside the record, but I presume those links led to Altice's form documents, including the customer service agreement.
Are you talking about the link on the receipt or a different link?
Well, as we discussed, there were links elsewhere as well, but yes, specifically the link in J22, the one that ends in / terms and policies.
That's not signed by him, correct?
Correct.
Okay, that's just the review your terms of service at alticemobile.com/legal/terms and policies.
Correct.
And the retail installment contract I thought we established earlier takes you to Altice Mobile's website. That's a quote from paragraph 9. Where a copy of this agreement and related.
It takes you to
privacy and-
/legal/privacy.
Correct. Quote, where a copy of this agreement and related privacy and other communications will be available to you. So it takes you to a host of documents on their website.
Correct.
And is it your position that when you said it satisfies both elements, including mutual assent on when you received the receipt and signed it, that it was as to the arbitration agreement, he would receive at a later point?
Well, the receipt was signed on the 20th, but the retail installment contract was obviously signed on the 25th after he would have received the email.
When did mutual assent take place?
Well, I believe at multiple points, but certainly once when he signed the retail installment contract.
On the earlier date, on the
The
20th?
later date, retail installment contract would be the 25th.
Wouldn't it be simpler if we simply had a document that said, I understand I'm giving up my right to a jury trial along with other phrases? I agree.
Sure, but that doesn't solve the underlying problem in the real world, where if that's what you deem to be required, which no court in the nation does, if you require that, you're putting the onus on the company to save the communication in whatever form it takes place, email or paper, query which is more burdensome, but they're required to keep it for every customer for the longest statute of limitations that exists in an applicable jurisdiction.
Wouldn't Rule 406 help you in that regard? And have an affidavit with active voice, not passive voice, that says, we always have our customers do X, including clicking and acknowledging and signing.
That would be ideal, but the question is, if you have a compliant Rule 406 affidavit followed by a signature, is that enough? And I think the answer is yes.
Anything you'd like to add?
No, thank you.
Thank you. Mr. Jacobson.
Thank you, Your Honors. May it please the court. I want to make a short point and then a longer point. I'll make the short point quickly because it's a short point. The appellate division came to a very important conclusion here that no one has brought up on either side, which is that there's no dispute here that a contract was formed. Mr. Fazio went in to have two contracts, but the main one I want to talk about here is the monthly service contract. He walked in knowing he was going to be paying by the month for a service contract. And so this is not a situation where a customer did not anticipate agreeing to a contract with terms. This customer walked in and knew he was walking out with a contract that obligated him to do something and obligated Altice to do something. So this is not a situation where we're debating contract formation. We're really debating what the terms of the contract were.
And that doesn't, in and of itself, that doesn't get you over the hurdle of Altice.
Absolutely not, Justice Patterson. But it is an important point here that I don't want to lose track of, but it's a short point. Here's the longer point. It is not unusual in circumstances like this for companies to have something short of proof of here's the email that I sent years later, because there are any number of ways that companies record assent. So normally there would be some kind of a declaration saying, here are our practices. So I've read the one paragraph order granting review in this case maybe 100 times. Every time I read it, I see something different in it. But the one paragraph does say, we're here to talk about the sufficiency of establishing assent through evidence of routine business practices without having, quote, proving that the practice was followed as to the plaintiff. I'm here as a friend of the court. I'm here on behalf of the Civil Justice Institute. And the one thing that I'm begging the court to not do is find that you need to come in with proof of acceptance by the particular plaintiff. I mean, 406 says what it says. And so
tell me how realistic this is in today's world. And that would be to require a sent email or some equivalent to it, or an explanation of with the business practice. Here's how we do it. And here's why we don't have every email back to the Carter administration. And that's because we have a document retention policy. And here's how that works.
That was a very pregnant or, Justice Patterson, because I completely reject what came before the or. What comes after the or, I think, look, Mr. Stone is correct, and also Ms. Weaver is correct. I mean, both sides here kind of, they committed to a course of action here where Altice put in what it put in, and Ms. Weaver decided, or counsel for Mr. Fazio decided, I'm going to take the position that this just wasn't sufficient. So nobody asked for discovery. Nobody wanted to go any further here. I've been sitting here for over an hour. I've watched the thought bubbles over every one of your honors' heads saying, I wish I knew more. Okay. I agree with Mr. Stone that no one asked for discovery below. I agree with Mr. Stone that probably means in most circumstances it's waived. But given that we're here and given that I can see the thought bubbles, I mean, what I would urge the court
I
not
didn't know they were showing.
very clearly. I mean,
Thank you for-
nothing was more clear, however, than Chief Justice Rabder's comment about Scoos, because there was a very wise guy who wrote a dissent in that case and read it a few times.
And didn't win.
Read it a few times before we got here, and I had a feeling what would be on the chief's mind. I had a feeling I knew what would be on a number of your honors' minds.
Can I ask you this? 406. All 406 gives a party the right to do is to use evidence of a routine business practice to prove that it acted in conformity with that practice. The practice that they want to prove that occurred here, that actually was followed, is that they sent an email out. That's it. The question of mutual assent is totally separate from whether they followed their routine practice. The practice of sending an email does not automatically mean that the plaintiff assented to the terms of the purported agreement. It depends on what the agreement says, etc.
So, Justice Fiscali, I agree with that to a point, and this was teased out by an argument from a number of people on both sides. It depends on the timing, which is another fact that's not in the record that the court doesn't know. Because if, in fact, it was described to Mr. Fazio, we're sending you this agreement right now, and here it comes, and here's our practice, I would be giving you a different answer, perhaps, than if it was sent at some point later. But again, it depends on a lot of facts that are not in the record. I'm not going to concede that sending the email after the fact might not be enough. It depends on a number of facts that are not before the court in this record. It is a somewhat exotic fact. I'm going to agree with counsel on this side that it's not a typical way to accomplish mutual assent, but it's not impossible to imagine that it would work here. But it does depend on facts that are not in the record. But I agree with Mr. Stone that it also was not challenged below. That was that at no point either in the trial court or the appellate division did anyone raise the quite astute questions that your honors are raising. But I'm sorry, go ahead.
The parties are not asking us to remand for discovery. Altice just pointed out we can decide this case on the record before us, and what the plaintiff wants is for us to reverse and remand for a trial. So we have the facts that we have on this case, on this record.
I can't disagree with that, with any syllable of that, Your Honor. I mean, I can't ask you to do something that the parties themselves are not asking you to do, and I'm stuck with the same record that they're stuck with. The one thing I'm asking you not to do, and I don't think you're inclined to do it, I hope, is to say that you can't establish mutual assent through evidence of a common practice. I mean, as I said, 406 says what it says. I think that the question that you asked the parties to prepare for today did not go to whether Altice actually did that here. I think that it would have been briefed differently. I would have briefed it differently. It's a situation where the question that was posed was, can you establish mutual assent through evidence of a common practice? You didn't. Again, one could read this paragraph in different ways. And Justice Fiscali, you have a reading of it that I don't entirely disagree with, but I don't entirely agree with either. I think if you had wanted the parties to address more specifically whether mutual assent was accomplished here through the evidence in the record, the briefing would have come in differently. I probably would not be the only amicus before you on this side. But that wasn't how this was done because, as again, Mr. Stone is correct, it wasn't raised below. And again, the appellate division found in no uncertain terms that a contract was formed. And then, that they accepted the evidence from the declaration that that the contract included the terms of the customer service agreement, which, as Mr. Stone said, is an Altice compliant arbitration agreement.
And so we have a form contract, we have a 30-day opt-out, which is obviously there's law regarding that. What we don't seem to have here is a record as to whether, relating their practice with respect to sending emails to what happened here. We don't even know for sure there is no email. And you see the missing gap seems almost the factually easiest gap to fill.
I couldn't agree more, but I also have to agree with Justice Fasciali that if the parties aren't asking you to do that, you're stuck. I hope you're not stuck. I mean, I'm particularly as the Third Circuit has clarified when you should go get discovery. I mean, it under Guadagni, it was sort of, okay, let's always have discovery. But I was pleased that the Third Circuit just a few months ago said, no, you do that when it's necessary, which it isn't always, it isn't even usually, it may be here. As I said, the one bridge that I ask you not to cross is to find that you must, what happened before your or, Justice Patterson. It can't be that the requirement is to come in with, here's the email, here's the IP address from which somebody accepted it, they accepted it at this date and time from this email address. That's too much to ask under this, under the circumstances, and as Mr. Stone said, no court in the country has required that. You must be able to prove mutual assent through evidence of your routine business practices. Whether that was done here or not is what the parties are disputing. Whether the trial judge should have had discovery and teased out some of these facts. If we were the trial judge, I think everyone in this room might have done things a little differently. I know, Altice might have put in a different declaration. Mr. Fazio might have put in a different declaration, sort of looking into the future at how this would all turn out. Whether you can order discovery when the parties aren't asking for it, I don't know. But
Counselor, can you establish mutual assent through evidence of a common practice that has been rebutted?
Oh, sure, Justice. I mean, Justice Hoffman, so imagine a world where Altice had put in an entirely different declaration containing all of the elements that Justice Patterson was talking about. Here's why we don't have the email, if in fact that's what's happening. Our retention, we keep it for 2 years. This was 2.5 years, so we missed by a few months. But it's done automatically, and this is what happened. The email got sent out, and a declaration came in very different from the one Mr. Fazio said, because I understood what Your Honor was saying before about a forensic expert, but the reality is if it was deleted 2 years earlier, it's gone. I mean, a forensic expert is not necessarily going to be able to help with that. Or as counsel for Mr. Fazio said, if it was caught in a spam filter and never got there. I mean, so in a world where Altice puts in evidence of this is what we did, and this is why we don't have every single piece of paper. And in a world where Mr. Fazio came in and said in an unequivocal manner, I did not get that message. I save everything and it's not here and I don't have it now. At that point, a judge has to make a decision as to credibility, as to all of the things that that a finder of fact has to decide. But yes, if that's what the record shows, you might very well need to either compel arbitration or not compel arbitration based on the evidence you have in front of you, which is imperfect. Because even if Altice had come forward saying, here is the email we sent, that does not preclude Mr. Fazio from saying, I didn't get it. I know I didn't get it. And here's why I didn't get it. Or they sent it to the wrong email address. Or I entered a typographical error when I gave them my address, and that's why I never received it. There are a million stories in the naked city. And any one of those things could have transpired, and then a trial judge would have to make a decision, what is the right answer under New Jersey law in that circumstance? Here, we've got a thin record.
Although those answers would have been undermined by his admission that he received emails from Altice relating to this subject matter at the same period of time.
I'm sure that's right, Chief Justice Ratner. And again, it's neither side put in a declaration right now that they would write today, given where we are. But I've been here many times before where this court starts to say, let's tackle some issues that weren't tackled below. It doesn't always go very well. And so, in an ideal world, I think you've either got to do what the parties are asking and say, okay, we're going to decide this on these facts, and they didn't meet their burden, or they did meet their burden, or you should send it back and say, we need to know more.
So a quick question about resolution of a disputed issue of fact. Obviously, it's in the best interest of the parties to have a decision made early on about arbitration. And if it was a fact issue, would the judge resolve that either by a testimonial motion or some kind of hearing as part of the application to compel arbitration?
It has to be resolved early, Your Honor. In fact, because if a defendant doesn't raise it early, it's waived.
Right.
So it is a threshold issue. It's one that under the Federal Arbitration Act, there's a right of automatic appeal if it's denied. And under New Jersey law, it ends up being appealable under both ways. But it does need to be decided early on whatever facts. If discovery is required, the trial court orders discovery. If it's not, it's not. Most times it's not. But it does need to be decided as a threshold issue.
Questions, anyone? Thank you,
Your
Council.
time.
Ms. Weaver, brief rebuttal.
Thank you, Chief Justice. So just very briefly, I want to sort of touch back on an issue that came up when I was initially up here and was touched on again, which is this question of when mutual assent occurred. And I argued earlier that the earliest it could have possibly occurred in this case with regard to the arbitration clauses would have been 30 days after the email was sent.
Sorry, before you get to that, can you get to the point that your adversary raised, which is none of this was ever argued below, and everyone always agreed that Rule 406 was satisfied and that they showed enough of their routine practice, and it was just whether Mr. Fazio had satisfied his burden?
So we didn't argue admissibility of the declaration below. As Amika said, probably going back today, I would raise that. However, we certainly argued the probative weight of the declaration from the beginning, and that was raised at the appellate level and of course before this court as well. So while I do think that it wasn't raised concerning admissibility, it was raised concerning the weight to prove mutual assent.
And you're saying that whether your burden was carried, that was that there was, you were arguing that your burden was carried, and you argued that their burden was not carried and that yours was. Am I right about that?
So I think my argument is that we didn't even reach the point of needing to show a burden of establishing a disputed fact. If we had, I do think that Mr. Fazio's declaration did as best he could because he doesn't have knowledge as to their business practice.
Sorry, can you say one more time? You didn't argue admissibility, but you did argue probative value. What does that mean in terms of, he says that I understood your adversary to be saying no time below did anyone say that this did not establish the routine business practice of this email being sent. Are you now saying that you conceded below that it did establish the routine business practice of this email being sent?
No. I don't think that it was really viewed as a question of routine business practice. It was just that the wording of the actual declaration didn't establish that anything happened, an actual event of sending the email or an actual practice. Because
and you pointed that out, that it was written in the conditional, that it didn't say, an email was automatically sent without a human sending it, or that X human's job was to send these emails or anything like that. You pointed all of this out below?
Yes, Justice. So one of our initial arguments in response to the motion to dismiss was that the entire affidavit was written in the conditional and therefore was not probative of anything actually having happened. And the question of routine business practice wasn't really fleshed out very carefully because just the things that were related in the affidavit in and of themselves weren't probative of anything.
What are we going to say about 30 days?
So that's the earliest. If there had been mutual assent, that's the earliest it could have possibly happened under this fact scenario. That being said, I didn't mean to argue that that would necessarily be sufficient under this court's precedents, that mutual assent in some sort of affirmative acknowledgement is part of the court's precedent and is required, just that the only arguable way that it could have happened here was allowing those 30 days to lapse without anything having happened, though perhaps still not sufficient. And then I just wanted to say—
you say the 30 days plus having provided the agreement to him?
Yes. So I think the only way that—
Are you taking position as to 30 days with no agreement being provided to him? Or are you saying 30 days plus evidence of routine business practices that would establish or meet their burden with respect to sending him that agreement?
I think he would have had to have received the email and then allowed the 30-day opt-out period to pass without doing anything. That's the only way, even arguably, that mutual assent could have been established here with regard to the waiver provisions of the contract. And then just the one more thing I did want to point out again is well, I guess two things. First, just how confusing all the language is between the terms of service and the customer service agreement and the service agreement. That really does muddy this issue of whether there was notice. And then finally, that, the individual rights that are at issue here, these are individual rights. And so allowing a business to say that we're going to let a large corporation prove that everyone waived their rights because we have this business practice, I think is not appropriate, because the reason that the law requires the knowing waiver of rights is because they are individual rights. And so it should be proved.
With respect to the hypothetical that was just discussed with Mr. Jacobson, if this is going back a number of years, if there's obviously millions of customers, there's a document retention policy that calls for certain documents to be deleted from the system because it just can't bear the weight of those documents. You're saying if there is not direct proof of every case, no matter what the circumstances, then there's no waiver?
Well, I think that these corporations that seek to bind customers through sending someone an agreement, that if that is an important term of the contract to them, that they should retain those documents. Yes, here Altice was able to provide all sorts of documents that go very far back, but they didn't have the email. So if it's a material term of the contract and they're going to have to prove it someday if they don't want to end up in court, I don't think it's a lot to require these corporations to produce those documents when they do want to bind someone to arbitration and prevent them from accessing the courts.
Thank you, Council.
Thank you.
It's been a long day. Something that we appreciate as the days get longer is having fine lawyers appear in front of us, and I want to thank Council. Take the matter under advisement.